Mentioning the matter is not coming in the list every day. Your lottery accepted my fair.
Is assigned to his lordship's bench or not. That is why it is not coming.
May I be permitted to
So please
mention?
mention before the right bench.
Lordship, may I be permitted to mention for inclusion of a relaxation of condition of bail? Great.
Nonetheless, we will check. If it is not assigned, it will come in the list.
Lordship, bail in connection with appeal.
My lord, may I be permitted to mention one appeal hearing to be added before your lordship in the daily list, my lord? More than 7 years in custody, my lord.
File an application for suspension of sentence. Will
It is last time rejected, my lord, by your lordship.
So what
Your
can
lordship
be done?
said, my lord, it will be added in the list.
It will be. It is in the
It's
list.
already in the monthly list.
So we'll consider it.
Bail in connection with the appeal and appeal hearing, my lord.
My lord, I am praying for inclusion of the matter in the list, my lord.
As what?
My lord, on 6th February, your lordship sir.
What is this case?
My lord, your lordship sir, pleased to pass the anticipatory bail to the petitioners, but subsequently, due to strong objection and obstruction by the some of the advocates of Chinsura bar, your petitioner could not attend and appear before the learned CGM.
It's
taking regular bail. My lord, I have
filed.
filed the CRAN, my lord.
We'll consider the crime.
My lord, bail in connection with appeal.
Grateful.
Yes, call the list.
I'm for the appellant, my lord. My lord,
Defects minor may be ignored. Paper book 6 weeks. Next. Item number 2, Lordship.
Lordship, appellant's advocate name are wrongly recorded, Lordship. Advocate on
Correction made.
And then item number 3, I'm appearing through virtually. And then,
Yes.
no, there is a correction of the record. There was only one applicant, and the order has been recorded in applicants in the plural form.
Correction.
And one further prayer, kindly direct to act upon the parties upon the server copies, my lord.
Enter petition.
Yes, my lord.
What petitioners be read as petitioner. Petitioner is given liberty to appear before the regular court within 4 weeks from the date from today. Full stop.
My lord, one thing, my lord, kindly direct to act upon the server copies, my lord. Grateful, Your Honor.
Next.
for the state. For the petitioner, Lordship. It's one typography in the name of the petitioner, Lordship. One L extra, Lordship.
Name of the petitioner corrected. Next.
My lord, in item number 5, my lord, in the assessment bill, the amount is 46,899. My lord, in the order sheet, it has been 2,46,899. Mistake, my lord.
Necessary correction. Next.
Amount of
petitioner, my lord. I'm for the refactor complaint.
The lordship has called for a report from the state.
The second page, last paragraph. Last occasion, they said that one
Now it is that.
Orang Sawadia
report question. Report.
আমরা কবে গিয়েছিলাম লাস্ট দেখতো ফার্স্ট দিন যে এগ্রিমেন্টটা দিলাম সেটা দেখতে পাবো।
So this Kovadia has not been interrogated as yet.
Because he's not cooperating.
This Gaurang Kovadia is not cooperating.
That the person who has given the money.
And also, my lord,
That your lordship has also called for the that we have supplied the agreement, which I said that the LTI is of him, but not the signature. Lord, I admitted, I've also admitted Lord before but that report is also not awaited.
LTI, his LTI.
Yes, Lord, de facto complaints LTI. I'm not another thing, Lord. The one person he has taken money since Lord he is the Lord.
The agreement is with you.
yes, my lord, it has been sent to QEDB for handwriting expert, my lord.
But similar complaint has been lodged against
my
him for
the
taking
meantime,
money
Lord-
and for not allotting lot plot.
In the
But
meantime,
since
my lord, we had supplied the documents to independent
to defend.
examiner, my lord. The report has come, the handwriting, and the signatures do not match. We have supplied those copies to the police.
My lord, may I submit another thing, my lord? My lord, regarding the ITR of the petitioner, my lord, they have said that they will give us, but they didn't give. So cash in hand.
But we have given the idea. We have given the idea.
So ITR not given, cash is not substantial.
Petitioners submit. They had entered into a sale agreement with the de facto complainant.
Lease.
Huh?
Lease.
A lease agreement with the de facto complainant over the property. They had paid a total sum of 4.55 crores against the said transaction. In light of the aforesaid, subsequently, the de facto complainant alleged the lease agreement is forged and no money had changed hands. Over this issue, criminal case has been registered. They pray for anticipatory. In light of the submission that petitioners had paid a sum of rupees 4.55 crores to the de facto complainant, we directed the investigating agency to submit report. Report is placed on record. From the report, it appears that the petitioner's claim has not been substantiated. It was alleged that one Kalimuddin Molli had purchased land from the petitioner and handed over 32.25 lakhs.
Kalimuddin is the petitioner.
Oh, it was alleged that petitioner sold land and received rupees 32.25 lakhs. However, documents furnished by him did not corroborate this fact. It was also contended that one Gaurang Kovadia had invested a sum of rupees 3.5 crores. Report shows
3.5
to said Kovadia, he has not responded. De facto complainant contends that his signature in the deed is forged. We have considered the materials on record. The dispute has cropped up with regard to authenticity. Of a lease deed purportedly executed between the petitioner and de facto complainant. While de facto complainant contends the deed is forged, comma, petitioner has strenuously argued that his LTI, a de facto complainant's left thumb LTI, is genuine and cash of 4.55 crores was handed over. Investigation conducted till date does not provide support to the petitioner's plea regarding payment of 4.55 crores. However, this court in exercise this court is not concerned with the execution of the deed in question. What is the principal concern of the principal concern of the criminal court is to determine whether the deed is a forged one, and if so, was the forgery done by the petitioner? Full stop. De facto complainant has relied on a private expert's report that his signature is forged, but petitioner contends that the left thumb impression of the de facto complainant is genuine. Suspect deed is in the possession of the investigating agency and has been sent for forensic examination.
For handwriting.
Forensic handwriting examination. Progress of forensic investigation would not require custodial interrogation. Would not require custodial interrogation. De facto complainant apprehends that petitioner is a powerful person and there is likelihood that he may be dispossessed. Full stop. Under such circumstances, we are of the opinion, though custodial interrogation may not be necessary, movement of the petitioner requires to be restricted in order to instill confidence in the mind of the de facto complainant and prevent commission of violence, prevent escalation of violence in the area. 10,002 sureties petitioner while on bail shall not enter Bhagavanpur police station, shall report so and so. He shall report once in a week to the investigating agency and hand over his signature and handwriting if necessary. If not already done.
I've given it already.
It's not already done.
My lord, document which is in dispute, my lord, this is not a lease deed. This is a notarial agreement.
Acha, we leased it ko na, a notarial agreement.
Lease deed.
What is the agreement?
That he will settle a plot in favor of us.
All right. Has entered into a notarial agreement to hand over a plot.
Obliged.
Next. ब्रेकफास्ट में हो
मिलने का
400 करो देखने का
नामগুলো দিয়ে দিন
नहीं तो दिल्ली में 4 करोड़
हम तो कमा के
1 करोड़ ठीक है ना रॉस This year has been a year of 15. Like, you will go back. Right, notarized agreement.
Well, 42406, well, at the outset, well, I am submitting, well,
Look into the first order.
there was a talk of settlement in between the parties, well, that has been failed. Well, on two occasions, well, interim, on two occasions, well, interim bail was granted. Well, it couldn't be done. Well, may I please the facts, well.
Second dumper, you have produced documents.
Yes, my lord.
That
That-
was also let out.
My lord.
So one
Total
dumper,
54 lakh, my lord. Total two dumper document I have produced before the
all right. Now,
investigating officer.
one dumper has been recovered.
Nothing.
No dumpers.
No
have been
dumper is
recovered.
recovered.
Well, during COVID, well, complainant handed over a dumper in lieu of, well, 4.5 lakh. Well, as per the agreement, out of remaining 48, well, I have paid 25 installments. Well, thereafter, I stopped paying. Well, this is my case that, well, they haven't handed over the documents. For that reason, I have stopped. Well, a proceeding has been drawn up against them. Well, it is their contention that additionally another JCB has been handed over to me. Well, that I dispute as per my instruction.
Please documents.
Well, he hasn't been handed over. Well, that document, is required to be verified, subject to lordship's
Verify the
confirmation.
documents. He says one dumper. What is how much have you paid?
Malad, out of 48, I have paid 25 installments.
Right.
More than
We want amount. How much have you paid?
Malad,
48
amount, Malad,
3 lakhs, 30 lakhs. How
Malad,
much?
Malad, that Malad, I have to take instruction. Malad,
But
but
already my
more
notice
than-
was given from the my lord. Legal
One
Service Authority,
second.
Guwahati.
How much has he paid against the first dumper?
I did not pay. For that reason, my lord,
He says he has paid. We are just saying did not pay. The surface proceeding can be
not servicing, my lord. My lord, hire purchase agreement, company, financial company, my lord.
Financial company has a right to initiate
Yes, my lord.
surface proceeding provided it has a security interest registered, right?
My lord.
So let us see whether how much has he paid, how much is outstanding,
My lord.
correct?
My lord.
And verify your second adjourn 1 week.
deep.
What a big and so yes, paid one
Interim order was there.
interim order extended by 2 weeks. Yes,
I am for the petitioner, your lordship. I have taken instruction, your lordship. I have taken instruction, your lordship. Allegation against two plot. One plot does not belongs to the petitioner. Other plot belongs to the petition number 1 and 2. But they will be able to pay 1/3, your lordship. That is about 6,27,000.
was there a permit to excavate sand?
No, no.
But
Then
this land
We
belongs.
have considered the
But this
materials
land
on-
is a agricultural land, your lordship.
So you cannot excavate sand from an agricultural land.
But I'll pay, your lordship.
You will pay. You will go to jail.
But the
it-
maximum punishment 5 years. I have
We-
cooperated with the investigation
You
officer.
will go to jail because these are organized crime activity impacting not only one individual but the entire society and the ecology. All right?
Kindly, your lordship.
Yes.
I take instruction that they will be able to pay the entire amount or not.
You pay for ecology damage.
But it's my agricultural land.
Tomorrow, if there is a flooding because of your illegal sand mining, will you bear the expenses state exchequer for support and rehabilitation?
No, not sand mine, your lordship, the soil, your lordship. Say
But the soil is, you have no right on the soil. You have a right to cultivate. You can't cut out the soil. Sorry.
my lord, kindly, your lordship.
I've heard you.
I'll restore
Petitioner
it.
submits
I'll
that
restore it, your lordship. Kindly, your lordship.
petitioner submits that
But they will pay the. They will pay the entire
damage is
entire.
irreplaceable.
They'll restore it as it was, your lordship. Kindly, your lordship. 5 years the maximum punishment, your
Maybe.
lordship. I have cooperated with the investigation, your lordship.
Brick illegally, what happens is as soon as they start the brick clean, they use for the department to take care. If the department chooses to wink and duck, it's for them. But we are not going to give you any relief.
My deep.
And mining. Entire Asansol area and open cast mining, any day the surface soil is going to collapse. What has happened? What has happened in the Uttar
My lord, I am for the petitioner. My lord, from two Bangladeshi national, 236 bottles of Fencidril was recovered. My lord, I was named only on the basis of the co-accused.
We have considered the materials on record. Investigation reveals involvement of the petitioner in trafficking narcotics above commercial quantity across international border in collusion with foreign nationals. In view of the nature of the crime, we are not inclined to grant answer.
Grateful to the please.
My lord, in this matter, my lord,
এটা কি আমাদের?
this is an order, my lord.
Hmm?
This is an order, my lord. This is, my lord, I'm speaking my mind
You
out.
don't understand what you're saying.
My lord, this is, my lord, in order, my lord, that notices can be served, because my lord, I did not find it in any other matter. But my lord, since my lord, your lordship is here, my lord, I just wanted this question, my lord, to be. I had this question to myself, my lord.
Yes, what?
Well, to an accused, my lord, to an accused, when under section 67 of NDPS Act, my lord, notice can be served.
Can be served, but the evidence will be only intelligence,
My lord.
not admissible evidence.
Right.
Not admissible evidence. Because this Shariful was arrested at that time.
No.
Then?
My lord, he is an accused, and my lord, this notice was served upon him. He was not arrested. It's more like a 41A notice, my lord, under section 67. So, my lord, for these offenses, my lord, this can be served.
Definitely. Arrest is not mandatory. You can always collect information from an accused.
But after that, he does not cooperate.
Who is Shariful?
Well, the petitioner before you.
Petitioner, so that's another ground for rejection. In spite of notice on the petitioner, petitioner evaded the notice and did not cooperate with investigation.
Grateful.
Next.
But he is
Well,
owner of the vehicle, my lord, absconding since 2022.
Rejected. Petitioner is the owner of the vehicle which was used to transport narcotics. He did not cooperate with investigation and had absconded. Keeping in mind the nature of the crime and prima facie involvement of the petitioner in transporting narcotics, we are not inclined to grant answer. Next.
Lordship, I beg to appear on behalf of the petitioner. Lordship, free fight between the co-villagers on the issue of
My lord, unit on the
Whose cow?
informant cow, my lord, unit on the wall of the petitioner, my lord. Due to that, my lord, fight took place with two families, my lord.
Father and brother was,
Nature of injury.
my lord, page 17 and 18. The brother received 10 stitches and the father received 1.
Three
Petitioner
petitioner, lordship, my lord.
submits that the incident occurred in the course of a trifling, the fight broke out over a trifling issue. They have been falsely implicated. They had no intention. They had no prior intention to. There was no prior concert or intention to commit the crime. They pray for anticipatory bail and a lawyer for the state opposed the prayer. We have considered the materials on record. Petitioners had assaulted the victims conjointly, causing serious injuries on the scalp, on the head, a vital part of the body. They were medically treated. Accordingly, we are not inclined to grant answer. In a absolutely residential area, safe sound.
Item 18.
But item 18, I'm praying for a day's accommodation, my lord.
Huh?
My lord, I'm praying for a day's accommodation, my lord. We have received the CD today itself.
What happened? This is
Explosive
My lord,
substance.
recovery of firecracker.
not firecrackers, sir.
My lord.
Explosive substances. We have considered the materials on record. Large volume of explosives was recovered.
Just have it. My lord. Caesar list, my lord.
Whatever. Keeping in mind the nature of recovery, we are of the opinion custodial interrogation is necessary for progress of investigation and further recovery. Nature of offense, we are not inclined to grant answer. Next.
But 109, my lord, dispute between two neighbors, my lord. Petitioner 6 also, my lord, sustained. There is case and counter case between two parties, my lord. This is suffered injuries on behalf of petition number 6.
Consider the materials on record. There was a free fight between parties.
19.
Physical injury and
Ah,
physical injury over the backside of the head and bleeding injury.
no, where is the CT scan?
Citizen report is there. I am appearing on behalf of the
Yes,
de facto complainant.
show us the CT scan. Nothing much.
Swelling is there.
Just swelling, but no injury.
The matter is very clear.
Yes,
He
no.
was admitted 21st, 21 December 2024. And 90 days he is in admitted. He discharged on.
Give anticipatory bail, he'll be discharged.
His injury is very serious.
Yes,
Teaching
sir.
is there.
We have considered. Petitioner submits that there was a free fight amongst neighbors. Case and counter case was registered.
Everything has come till now.
Pray for anticipatory bail. Learn a lawyer for the state opposes the prayer. Learn a lawyer for de facto complaint submits that victim was hospitalized for a considerable period. We have considered the materials on record. There was a free fight between the neighbors. Full stop. Both parties suffered injuries. Though injuries are grievous, it does not appear that the act was a premeditated one. Under such circumstances, we are inclined to grant anticipatory bail subject to condition they shall meet the investigating officer once in a week and further. Next.
My lord, I'm for the petition. My lord, the husband committed suicide. My lord, by taking poison. My lord,
Very
the
good. Who are you?
My lord, wife and the mother-in-law and the brother-in-law of the deceased. My lord, the wife was not there.
Huh?
Wife was not there at the time of suicide. He was in his house, while the wife was father's house. Besides,
Where
this,
suicide? Where did he die?
my lord, in his own house. Parents was there. Parents of the deceased was there. Wife was not there. Wife was father's house. And my lord, beside this, my lord, the husband has been suffering from schizophrenia. My lord, since before his marriage, in the year since my lord, 1916, and concealing the fact of his disease, my lord, the marriage was given. Mother-in-law, my lord, the brother-in-law.
Petitioner submit that petitioner number 1 is the wife of the victim. Petitioner number 2 and 3 are his parents-in-law. There was matrimonial dispute and petitioner number 1 was residing at her parental home.
No, both are residing in the rented house.
No, the lady was not residing with him.
No.
Yes, my lord. Lady and my lord, the petitioner number 1 and her husband, my lord,
The day of incident, she was not. Then, acha, on the day of the incident, petitioner number 1 was residing at her parental residence. Victim suffered from schizophrenia and had committed suicide. They pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Petitioner number 1, victim had married petitioner number 1 in 2016. There was matrimonial discord, full stop. On the day of incident, that is 18/8/2024, victim was alone in his house and committed suicide. It is alleged that petitioners had misbehaved with him. It is alleged prior to the incident, petitioners had misbehaved with him. Whether such misbehavior per se would constitute abatement to suicide may be assessed at the appropriate stage of the proceeding. Victim had not left behind any suicide note implicating the petitioners. Custodial interrogation for progress of investigation is not necessary. Accordingly, we are inclined to grant it.
Petition number 3 is brother-in-law of the deceased.
Huh?
Petition number 3 is brother-in-law.
And 2?
2 is father-in-law.
2 mother-in-law. Acha, petition number 2 is the mother of petition number 1 and petition number 3.
2 is mother-in-law. Petition number 2 mother-in-law and petition number 3 is brother-in-law.
We have considered it. We are and brother-in-law of petition number 3. Yes. Next. Petition number 3, right? Petition number 1, brother is petitioner number 3.
Petition number 3 is brother of petitioner number 1.
Next.
I'm for the petitioner. 406, 420.
22, my lord. I have just received the case diary, my lord. It's voluminous. Can I?
406, 420 voluminous.
2 volumes.
That is why we are granting anticipatory bail, because it is based on so much of documents. Custodial interrogation is not.
My lord, I have
Petitioner is Milord
Oh,
proprietor.
cyber crime.
No, not cyber crime. Milord. There's no cyber crime. There's no cyber crime, Milord.
loan transactions.
The petitioner, Milord, he runs, Milord, a concern which deals, Milord, with harvesters and parts of tractor. Now, Milord, Robi Lochon Pan.
Chal. Tomorrow.
Well, Friday, Milord. Kindly take it up on Friday.
Friday.
I'm deeply okay. Right.
Yes,
23, my lord, I am not today, my lord. I have not received the CT, my
not today.
get.
Not received the CD, your lordship. Shagardegi PS, one day. Today I will receive.
Electricity.
Today I will receive.
Yes, yes.
What is the amount?
2,35,962.
Undertakes to pay 50% of the provisional assessment bill
Provisional
to
bill.
the tune of so and so within 7 days.
Lordship, 10 days.
Within 10 days. Adjourn fortnight.
Right.
Lordship, in the meantime, please will not.
This is not even interested in it.
I'm grateful, my lord.
Next. Yes.
198, my lord.
I'm not a statement.
Yes, Sonali Das.
My lord.
We have considered the materials on record. Allegations against the petitioners, that is parents-in-law of the victim lady, are general and omnibus. Custodial interrogation for investigation complete or going on?
No, not
Is not necessary. Accordingly, we are inclined to grant answer.
Grateful.
Over. Sonali Das. Not saying, alias, Sonai and Sonvila. You don't have instruction.
Personal note, my lord.
For the petition. A dispute between two families, free fight, case and counter case is there.
We have considered the
not the
materials on
principal
record. There was a free fight between two families. Case counter case was registered. Nature of injury.
Simple, Lordship.
Nature of injury. As per injury report, injuries are simple. Accordingly, we are inclined to grant answer. Next.
I'm for the petition, Lordship. Electricity Act, Lordship. Final order of
3,19,000 and odd.
50% of
Final-
final assessment
final
bill to the tune of so and so within 7 days,
10 days, Lordship.
10 days, fortnight.
My lord, I'm for the state, your lordship.
My lord, I am for the petitioner, my lord.
My lord, I have received the brief in the morning. If my lord kindly passes it over, I'll just come back, your lordship. Because in this case, my lord, there is a direction of the, my lord, Justice Tirthankar Ghosh to take this person into custody if required.
No, not on the basis of
If
that.
required,
Yes, your lordship.
no judge has the power to direct arrest. It's your prerogative.
Yes, your lordship. So in
Required, all right.
And then not today, my lord. Tomorrow I'll do this.
One second.
My lord, doctor issued one prescription, my lord.
Oh,
That verification of the prescription was short for my lord.
surrender.
My lord,
You are masquerading as a false doctor.
my lord, my humble submission, my lord.
Your humble
The hand,
submission.
my lord, the prescriptions, my lord, written by the doctors, my lord. So far, the my lord, handwriting and the prescription, to that effect, my lord, no whisper. Only the registration numbers, my lord, reflects on the prescription, my lord. To that effect, it is stated that that doesn't tally, my lord. And this,
Show us your registration number.
my lord,
Show us your registration number.
no, my lord, this was my lord, supplied, my lord. This petitioner was unconscious. He was taken to the hospital. The doctor, my lord, treated him and prescribed. But this is my instruction, my lord. And my lord, CCTV
doctor-
footage was there, my lord.
the doctor has submitted a complaint regarding.
Yes, and stating that, my lord, the registration numbers.
Shit.
Doctor prescribed the medicines, my lord, observe the patients, my lord.
So you prepared a false medical certificate.
My lord, he has prepared a false.
And that's what we are saying. He's
Yes.
prepared a false medical certificate.
Yes, your
This-
lordship.
This,
For what?
my
My
lord,
lord,
this,
my lord, he filed a writ petition saying that he had gone to file a lodge a complaint. However, police refused to accept the same.
my,
That was the
petitioner-
allegation.
Hmm.
My lord, after that, he comes up and says that he has been beaten up. He cannot enter his house. He was trying to enter and he was
That
beaten.
medical certificate is false.
Yes, your lordship.
Where has
So-
he used it?
My lord, he filed it a supplementary affidavit before this honorable High Court. In that medical certificate
Custody.
was supposed to be.
Custody.
My lord,
including all who have helped you to prepare this false medical certificate.
my lord, my lord,
Police in action.
yes, my lord, police in action, my lord.
Now you see police action.
My lord, that is my lord.
Petitioner submits that.
But so far, my lord, the prescriptions, handwriting of the doctors, my lord, that can be observed. My lord, there is no, my lord, whispers. My lord, only the registration number.
You whisper you were not admitted, but a medical certificate showing you were admitted.
No, treated, my lord. Treated before the doctor, my lord.
You were not treated.
But this is, my lord, kindly see these, my lord,
we are seeing, we are rejecting it. We will have to see. Petitioner submits he had been medically treated and there is nothing to show that the handwriting of the doctor is false. He prays for anticipatory bail. Learned lawyer opposes the prayer. We have considered the materials on the allegations disclose a very disturbing state of affairs. Petitioner alleged that he had approached the police. Petitioner alleged that he had been physically assaulted and treated and hospitalized. Was he hospitalized or treated?
No. He was taken to hospital.
And treated in the emergency department of the hospital. In support of his alleging, police did not take cognizance of his complaint. He approached this court in writ jurisdiction. In the said proceeding, he submitted a supplementary affidavit enclosing a medical report, which upon inquiry is found to be a fake one. Full stop. The medical officer of the concerned health center lodged the FIR. The aforesaid materials show that petitioner has prepared a fake and fabricated medical report of a primary health center and dishonestly utilized the same in a judicial proceeding. Full stop. In light of the materials on record disclosing involvement of the petitioner in the daring offense of using forged document in judicial proceedings, we are not inclined to grant admission.
Great.
Oh, now come, go, see action.
But I do not support this.
Police in action. You move the writ.
My lord, no, he was appearing
my lord,
in person and then the
in
last occasion he
person.
did not appear
and
in the
he
last
is a
occasion.
student of my lord
Kingston College.
Adia law student.
Yes, your lord.
I do not support my lord this practice, but
He shouldn't be he's a client, not a student.
My lord, I repeatedly asked him, my lord, he was saying that no, it is genuine.
No, it's
11 in the morning, my lord, he called me.
Let him go to custody.
41 and notice was served, my lord, he did not comply.
We would have given him anticipatory bail had he not used it in any place. He has intentionally used it. Next.
My lord, I am for the petition. My lord, complainant is one of the partner of a partnership house. My lord, in the year 2024, in the month of September, they intended to purchase 7 acres of land, 140 cutters of land adjacent to a temple. Now, my lord, page after page 7, page 8, my lord, one of the partner entered into an agreement with the puja committee, and they agreed to transfer 4 cutters of land which is adjacent to the mandir, to the temple, out of 140 cutters of land. Now, my lord, thereafter, when the puja committee, my lord, asked for transfer of the land, all of a sudden, in the month of January 2025, one of the partner lodged this complaint saying that we have threatened them if this cutters of land is not transferred in our name, we will ransack in their office and car. My lord, your lordship had the occasion to release this matter earlier also. My lord, may I just take a lordship to this order? My lord, during pendency of the anticipatory bail application, the person was arrested. My lord, without serving any compliance of 35. Thereafter, was sought for an affidavit from the IO. Now, my lord, I am other member of the puja committee. My lord, kindly cease the allegations. Kindly cease the allegations.
Let him meet the investigating officer. We keep this along with this. Petitioner contends that the dispute arises, the dispute is civil in nature and involves civil in nature. Petitioner and other members of a partnership firm entered into an agreement to purchase a portion of land from a land to construct a temple.
No, my lord, it is adjacent to temple.
Land
not to purchase.
from-
They agreed that they will transfer this 4 cutters of land which is adjacent to the temple in the name of temple committee. Out of 140 cutters of land, they purchased 140 cutters of 7 bighas of land. The adjacent land, my lord, that was the agreement. That one of the partners that was agreed that they will transfer it in the name of a temple committee, not in name of any individual.
Whose temple committee?
Temple committee.
We are not. You are member.
My lord, I am also a member of the temple committee. We all went to them for requesting them that this was agreed. Kindly transfer this land. Then they lost this complaint.
And
They are local goons. They want 4 cutters of land for constructing temple.
My lord, it is not that. Kindly cease the
Otherwise,
agreement. It was
4
agreed
lakhs.
by one of the partners.
Why should they give you land?
Not allow you
My lord,
to do any work.
Why should you allow? Why should you get land for temple? Why?
No, my lord, the temple was.
Why they will build temple in their land?
No, the temple is there. There is an existing temple.
Let them build
The
temple.
adjacent land.
Correct.
There is an adjacent land.
Acha.
That is
All
all.
right. As of now, we are.
Should we give the adjustment land?
Absolutely. Absolute extortion. Absolute extortion.
My lord, if they do not, that was agreed by them only. Thereafter only, my lord, we went there. It's not that individually anybody went there and asked for it. It's the villagers. They only went there, my lord.
Where's the agreement?
My lord,
Where's the agreement?
where they live.
Where the agreement?
No, my lord, this
There
is
is no agreement.
This is
Demand.
not, it's an instrument. No, my lord, it's an instrument. My lord, that is true, my lord.
You are good.
So in page 8, my lord, in page 8, I have annexed that where one of the partner agreed and signed that instrument, and my lord, other one.
Gun on his head and you have got this.
What sort of agreement?
It's not an
What do you
agreement.
say?
It's an.
We are keeping this with the other one. When this is coming up? 6-3. 6-3. List along with 6-3-2025 petitioner shall meet the investigating officer once in a week in the and cooperate with the investigation. Subject to aforesaid, he shall not be arrested for 2 weeks or until further orders, whichever is earlier. Let us see what affidavit they give. Why you arrested? You show us that they were threatening or something. Then on that premise, we reject it. Next. Give me 7 cutters. Simple. Chota.
Lordship, no narcotic substance was recovered from our possession, and only co-accused person's statement has been transferred our name.
Lord, he's absconding for more than 2.5 years.
Huh?
And my lord, he's absconding for more than 2.5 years. And
We have
Lord,
considered the
order of
materials on record.
proclamation has
Petitioner
been
had absconded for 2.5 years. He did not. We have considered materials on record. Full stop. Quantity of narcotics recovered from co-accused is below commercial quantity. No narcotics was recovered from the petitioner. His complicity has transpired from statement of co-accused before police officer, which is inadmissible in evidence. Under such circumstances, we are inclined to grant anticipatory bail 10,000. If we reject it, after next 2.5 years also, you will not arrest him.
I'm for the petition. The allegation under section 420, 460 Indian Penal Code. My lord. Allegation is that the petitioner is a 72-year-old lady advocate practicing in Arambagh Court had entered into an agreement with the de facto complainant for selling of land. But after 2 months, the de facto complainant came to know that the petitioner has made an agreement with another person, and immediately he wrote a letter to through his advocates. After that, the petitioner has paid 7 lakhs out of rupees 20 lakhs. What is it? He has alleged that de facto complaint out, but it is 15 lakhs in cash.
Petitioner submits that the de facto complainant had entered into an agreement for sale. That he had entered into an agreement for sale with the de facto complainant.
She is a 73-year-old.
No, petitioner.
That is the petitioner, madam.
Okay. Petitioner had entered into an agreement for sale with the de facto complainant. Subsequently, she entered into another agreement for sale with another of the self-same property with another person.
But as per my instruction, she has not entered into any agreement.
All right. Subsequently, she cancelled the agreement and has returned part of the money advanced.
No, my lord, there is no cancellation due.
All right. She prays for anticipatory bail.
The notice 35 3 BNSS.
What will you do with that 35(3) BNSS notice? Recover the money.
My lord,
Then what? Tell us what investigation we will do.
the agreement, the original agreement with lying with her.
So go and search. Go and search. Your police officer is too lazy. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Dispute arose. Dispute centers around alleged breach of contractual obligations arising from a sale agreement. Mere breach of terms of sale agreement per se would not attract the offense of cheating. Under such circumstances, we are inclined to grant answer.
All right.
Next.
My lord, just received the CD. My lord, I'm praying for state.
The altercation took place among the members of the family over the issue of consuming medicine.
Injury.
There is no such injury.
Scuffle. We have considered the materials on record. There was a scuffle amongst family members. Allegation of physical assault is not supported by medical evidence. Accordingly, we are inclined to grant answer. Much minute. Will come after 5 minutes.
2024. The report. My lord, on 6 occasions, 500 statements for the charge taken.
My lord, I am for the petitioner.
My lord, on the last occasion, accused, Adibul Sheikh and Manoj Khan have filed a
कोई order था दें?
Adibul has withdrawn that application and Manoj Khan's application was heard, but no order was passed. And my lord, on the last day, the order also says that Arindam Roy has filed a discharge application on the ground. And time is also being taken. File discharge application.
I am for custody, my lord, 1 year, 1 month. Other co is granted bail by your lordship. I have annexed the order, my lord. The order to order একটা পাঠিয়েছি দিয়েছেন হ্যাঁ একটা দিয়েছি এই যে আরেকটা নিন আরেকটা কপি সেকেন্ড জাজ
So far as the two are concerned, first two, we have not pressed the discharge application also. Well, they are the, your lordship perhaps recollects, your lordships had the occasion to deal with this matter. Well, it relates to a person being released on bail on the basis of a forged order under section, under the 389 CRPC. Now, so far as these two are concerned, they are the brother-in-law and the son of the person. Now, so far as they are concerned, what I could get from the materials, my lord, they were given the impression that their father's bail would be granted. They have paid, the son had paid 27 lakhs to the third petitioner in this case, the Arindam Rai. Now, and now they are in custody for about more than a year. Now, my lord, what we could understand, my lord, after that we have even not pressed the discharge, prayer for discharge made on their behalf. My lord,
Arindam,
he has not filed any application. He has indicated that he would,
Taken time to file a discharge.
and that was allowed by the learned judge also. My lord, yes,
10 তারিখ
10th of March for framing of charge, appearance and production. No, I am there for the third one also. They even know. He,
তাকে তো আমি ডিসচার্জ করতে নিষেধ করেছিলাম আমি নো অবজেকশন দিয়েছি ওর নতুন
my lord, we have given our no objection in the trial court, but as of now, we still remain here.
রেশ ওকালতনামা ফাইল ওখানে লেখা আছে
He has not, that's, if your lordship kindly sees. No, then he says, that's why your lordship will find learned advocate for accused number 2, namely Arindam Rai, files fresh Vaklatnama and prays for time to file discharge application on the ground that
দাঁড়িয়ে ছিল নাম জানি না সাঙ্গিং চ্যাটার্জি
Agnik Chatterjee. Learned senior counsel can be
না না সিনিয়র কে
এই ক্ষেত্রে আসুন
Well, this is a jail appeal, my lord. I have now filing the memo.
My lord. So for my lord, the defect is concerned, I have checked my 2 page of the my lord judgment is missing, my lord, from the certified file. Then my lord, I have to obtain another set of it and 14 days delay, but that will be considered after because last page is not there stamp. Certified. Yeah.
30. Where can there be a direction for the state?
I am for the appellants, man. No delay.
I am for the appellant, my lord, under my lord, I am for the appellant, my lord, under 498 A 302, my lord. Punishment is life, my lord.
But I am for the appellant, man. The affidavit of service, my lord, section 5, it was restored, my lord, early, my lord. But I am the keen of the deceased.
Yeah, I'm not here.
My lord, not really, I have explained that particular. With respect to Mallikarjun non-applicability, I have explained. My lord, first, the brother has filed special leave to appeal. He died, though.
Yes.
My lord, he died. Subsequently, person.
Brother, not. There is another de facto complaint.
But de facto complaint has filed the appeal because he was the de facto complaint of the case. Subsequently, he died. CRMSPL when withdrawn. Or phrase it has been filed. This person is not connected with the deceased person. That is why he is seeking leave to file appeal. Not I have explained, my lord. Kindly come to my lord. My application, my lord.
The brother.
Brother Achita.
Huh? And the brother. She had unmarried. He was unmarried. Mother বেঁচে আছে একটা লিভ যদি দেয় তাহলে মাদার ফাইল করে
আমাদের অ্যাপ্লিকেশন দাও না But earlier leave was granted to file this appeal. That is why CRMSPL leave was granted. That is why we are filing. Well, kindly give me one day because there are lots of CRAN application. I have annexed everything. Only one day, my lord. I will explain. My lord. Clear হয়ে গেছে
Item number 43, Lordship, there was a direction to serve the special leave petition and section 5 application. By hand, Lordship, it was effected upon respondents 2 to 5. Upon respondent number 4, Lordship, his brother received it. By post, Lordship, we are yet to obtain the track report, Lordship.
Forty-four, my lord, I am appealing for the petitioner. Last stock agent, your lordship directed my learned friend to take instruction about
any threatening over the victim. My lord,
Lordship, as per information, there is no threat perception from the petitioner. Last para, Lordship.
my lord, all are now in custody. My lord, I have the certified copy of the order. All accused are surrendered before the learned court below and are in custody. 6 accused, only petitioner.
Lordship.
My lord, next week.
Compliance. এদিকে
মহাদুর হোসেন
My lord, I am for the petition appellant, my lord. My lord, 12 years, my lord, have given NDPS. 8 years I am in custody in view of Southern Singh, my lord. 12 years.
Good question, sentence.
Southern Singh. লিখে দিচ্ছি
Alert Mr. Mighty is appearing for NCB in this matter.
স্পেশাল কোর্ট NDPS অ্যাক্ট বহরমপুর হ্যাঁ লিখে দিচ্ছি ডিপলি মানে পেপার বুক বি প্রিপেয়ার্ড পেপার বুক
My lord, paper books have been collected. Have been prepared and they have been collected by us.
ডিপলি ডিপলি
In this matter, Lordship, I am appearing on behalf of the petitioner. Lordship, I am in jail for about 10 years and 2 persons have been enlarged on bail and the victim lady deposed that she has been forcibly married with his maternal uncle and her mother asked him to sleep with this lady. Shubham Sharma.
He was convicted for 20 years.
Shubham Sharma.
As he is concerned. Chitra Sharma was the one who purchased, kept in a house, and his son, Miss Loeb, ravished her for a continuous period of 2 months, my lord.
Not principal, Lordship.
Among the others.
Principal is Rahul Yadav. She herself deposed. Rahul is responsible for the whole thing.
Rahul was the one who took her from him.
Then, hey, Sahib, at page 5. At page 5, first para, I have stated that Rahul is responsible for the whole thing and Rahul has been enlarged on bail. At page 5, Lordship.
He was convicted for?
Shubham Sharma. And regarding Shubham,
From Sharma, alias Loeb.
alias Love,
Love.
Lordship. Allegation is that her mother asked him to sleep with her. Rahul at page 5 and he has been enlarged on bail. I have annexed, Lordship. আমি যাচ্ছি চলো Rahul and Chitra Sharma, mother of Shubham.
No, 10 years. 10 years.
There is a little mix up, my lord. Item 50 to 55, they are on section 50. And 56 to 60 is are those 52A matters. And out of 50 to 55, all convicted persons from the same appeal, I am appearing in 50 to 53. My lord, my contention is, it is admitted that the contraband was recovered from the pocket of the person, no such option given under 50. The independent witness says so, the IO admits so. Section 50. Well, the incident happens in 3 parts.
50-51, I am for the appeal.
Pocket. My lord, kindly see. PW 10 is the independent witness and 13 is the IO, the cross. Oh, acha, 50 টা বল।
50 থেকে 50 and 51 দেখি 52 53 বেলছেই
এটা তো মনে বুঝো not today, not today. Lordship, as per prosecution case, on 2nd of November 2018, from the pocket of Mohibur Rahman, 100 grams of Java tablet was recovered. Now, so far as Mohibur Rahman 100 grams of Java tablet is concerned, in that case, option has been given. Now, on 6th of November 2018, as per leading statement of Mohibur, 4 other accused, Shamol Jadov, Orindam De, Shahin Mondol, and Vishnu Pradhan was apprehended, and from them separately 212 grams, 63 gram, 104 gram, and 212 grams of Java tablet was recovered. In these 4 seizure, no option was.
Nah, pocket. My lord, that is the evidence that I am on search of the person from the pocket. My lord, evidence. Anirban De, Shahin Mondol. My lord, 6, the incident of 6. My lord, that is the evidence.
Shamol Jadov. Now this Shamol Jadov, Lordship, kindly see, Second seizure. A2 এক মিনিট না না একই ব্যাপার দ্বারা
শ্যামল যাদব
A2
CRA 19 number 2
accused number 2 CRA 20 হ্যাঁ CRA 19
A4
that is the seizure dated 6th of November 2018. The only gazetted officer subject to correction is PW3 and that is in respect of seizure from Mohibur.
আগের দিন এটা ডেটাই আলাদা
First day of seizure, that is on 2nd of November. That is the only gazetted officer in this case.
হ্যাঁ এভিডেন্সে বলেছে Now, my lord, that is the kindly sees the evidence of PW13. My lord, I have ticked mark. In the cross, he has admitted. Search of person and recovery from pocket. Search of person. আর নেই এটা ওই PW13 আর কপি নেই যেটা উপরে দিলাম এখানেই আছে একটা 13 এর কপি একটা উপরে দিচ্ছে একটা দাও My lord, the search your lordship will get PW10 independent witness. I have marked that portion. He also says upon search contraband was recovered, my lord, of the person. Search of the person. The words used by PW10. SI Ujjwal something, my lord, conducted. That's Ujjwal key একটা জানি।
PW10 is Gopal Das. He is an
Independent witness in respect of the incident of 6th.
Second seizure.
That my lord, that is what the IO says. My lord, kindly seize the independent witness PW10. I have handed over the evidence. আরে কপিটা দিতে পারছে না এই যে my lord, the words used. One blue colored plastic packet containing some tablets were recovered from one person. On search of those persons by SI Ujjwal Ghosh, tablets were recovered from all of them. And the IO in his cross admits, yes, there was such. PW13, I am tick marked that portion also. সিজার লিস্টটা তো সেখানেও বলেছে আরে ও আর একটা কপি দিতে পারছে না বুঝো একটাই তো কি আমার কাছে করছো দেখো না এর মধ্যেই তো 13 এর দাও না কালকে ভুলে রাখলাম এটা রেডি করে
আমি তো জাস্ট এই সুবিধার কাছে আছে নাকি
উপরে চলে নিতে পার has seen. Now the IO, your lordship, comes to further cross-examination of PW 13 on that page 29/8/2022. The paragraph beginning with middle of little below, true that the contraband substance recovered from the pocket. And he says such. My lord, I am Anirban A3 and A4 Shaheen. A3, A4.
That is item number 52 and 53.
Vishnu Pradhan.
No grant application. I don't know 54.
Vishnu Pradhan A5.
Yes. No grant. No grant.
Mohibur is the first day Caesar A1. A1, first day.
51, CRA 20.
Second day Caesar.
So Shamol, Sahin and Anirban are the second day Caesar.
And Vishnu.
And Vishnu, but Vishnu has not filed it.
যেগুলো
Not
গ্র্যান
filed.
আছে সেগুলো জিজ্ঞেস করুন।
Shamol, so all right. Take down.
May I submit one thing so far as the Mohibur is concerned, subject to correction? Lordship, Mohibur in respect of the first Caesar. Now, Lordship, these PW3 gazetted officers exhibiting GD.
You want a conviction upheld? One argument and we don't agree, we'll dismiss your appeal. প্রথম ওই মহিবুরের অ্যাপিলটা দাও। Learned counsel for appellant contends the recovery of Yaba tablets from appellant has not been proved beyond doubt. The gazetted officer PW3 contended
The evidence is written. I'm saying.
gazetted officer PW3 has not supported the prosecution case Yes, what you are saying about gazetted officer? What you are saying about gazetted officer?
This gazetted officer PW3 exhibiting exhibit 7 proves that on the date of incident at 11:15 hours, he left the PS to act as a gazetted officer in the instant case. But as per PW1, this appellant was detained at 2 p.m. and thereafter intimation was made for presence of gazetted officer.
কি বললাম জানো না না বলো যে সার্ভে the recovery has not been proved. Presence though appellant was detained at 2 p.m. Gazetted officer contended that he had
এতক্ষণ হাতে ধরে বসেছে এটা দেখছো নাকি? আজ তোমাকে বলছি পাঠ করতে।
inspection memo to
No, GD&T Exhibit 17 was exhibited by PW3 during examination of PW3.
exhibit 17.
17.
Not 7. 7 is an inspection memo.
No, 17.
No.
This was for GD entry.
GD entry.
All right. All right. কি বললাম জানো? না GD General Diary entry exhibit 17 shows that the gazetted officer had left the police station around 11:55 a.m. 11:15 a.m. This improbabilizes the fact that the said gazetted officer had been requisitioned for the search pursuant to the option given by the appellant. We have accordingly praised for there is infraction of section 50 of the NDPS Act, and he prays for suspension of sentence. Learned lawyer for state opposed the prayer. We have considered the evidence on record on 2/12/2018 on receipt of credible information. PW1 and other members of the raiding party detained the appellant. Full stop. He was given option to be searched by a gazetted officer. He he was given option under section 50 NDPS Act, bracket option 1, and desired to be searched by gazetted officer. PW1 contacted PW3 gazetted officer who came to the spot. Thereafter, the gazetted officer again gave an option to the appellant to be searched, option 2. He reiterated his desire to be searched before PW3. Search was conducted and recovery and how much?
100 grams of Java tablet.
And 100 grams of Yaba tablet were recovered. Full stop. The aforesaid evidence prima facie shows the presence of the gazetted officer. Prima facie shows that options were given to the appellant under section 50 NDPS Act, informing him of his right to be searched before a gazetted officer or a magistrate. He exercised his option to be searched before a gazetted officer. PW3 was summoned to the spot and the search was done. It is contended, referring to Exhibit 17, it is contended PW3 had left the police station earlier to the apprehension of the appellant. This improbabilizes the fact that he had been summoned by the police by PW1 to witness the recovery. A scrutiny of PW3's evidence would show he had left the police station for police work at 11:55 and was on duty at Hajra Crossing when he received the intimation from PW1 to proceed to the spot for witnessing the search. Witnessing the search. The prime officer witnessing the search, prima facie evidence on record, prima facie establishes compliance of Section 50 of NDPS Act. Under such circumstances, and in view of restrictions under 37 of NDPS Act, we are not inclined to suspend the sentence. এরপরে অন্যগুলোর করো। হ্যাঁ, appellants contend that recoveries were made on 2 dates. Alleged recoveries of Yaba tablets were made on 2 dates. On 2/11/2018, কত 100 grams? 100 grams of Yaba tablet was recovered from
Mohibur.
One Mohibur, one Mohibur Rahman, alias Rahman, full stop. During further investigation, second investigating officer PW3 conducted raid in the house on please give PW13 call data
6/11.
On 6/11/2018 conducted raid in the house of Anirban De, full stop. As per PW13, Anirban De, Shahin Mondol alias Bantu, Hapijul Sardar, তাই তো?
No, Hapijul Sardar third season.
That's it.
আচ্ছা,
Bishnu Pradhan and Shamol Jadov.
Vishnu Pradhan and Shamol Jadov were present. Each of the aforesaid accused handed over polythene packets containing Yaba tablets. The tablets were accordingly seized. He admitted no option had been given to the appellants under Section 50 of NDPS Act. Relying on the aforesaid evidence,
Independent witness.
Relying learned counsels for Shahin Mondol and Anirban De contend their PW10 also admit PW10 an independent witness also admits no option had been also does not refer to any option given to the said appellant to the aforesaid appellants under Section 50 of NDPS Act prior to search.
And there were persons were searched, he says.
Coming to relying on the aforesaid evidence, appellants pray for suspension of sentence. Learned counsels for state submit the appellants had voluntarily handed over the polythene packets containing Yaba tablet. No recovery was on the strength of voluntary submission. Recovery of the tablets did not entail search of their bodies, at which would attract compliance of Section 50 of NDPS Act. We have considered the rival submissions at the bar. It is true PW13. It is true. In chief, PW13 stated that appellant stated that Shahin Mondol alias Bantu, Anirban De and others had voluntarily handed over polythene packets containing Yaba tablets. But during cross-examination, he admitted that the recoveries were from their pockets pursuant to a search. The PW13's version during cross is also corroborated by the independent witness BW10. In light of the aforesaid evidence on record, it appears that the recoveries were pursuant to a search of the Apple of Anirban, search of Anirban, they and Shahin Mondol, and not Shahin Mondol, which would attract compliance of Section 50 of NDPS Act. In given this, admittedly, no option. Admittedly, appellants were not informed of their right to be searched in presence of a gazetted officer or magistrate as per Section 50. Given this situation, Anirban De and Shahin Mondol alias Bantu has made out an arguable case of breach of mandatory requirement, breach of compliance of Section 50 of NDPS Act in respect of the alleged recoveries made from them. Hence, we are inclined to suspend their sentence. Full stop. They shall be released.
Shamol Jadov is also in the same category.
ওই হ্যাঁ
শ্যামল
ওই অনির্বাণ দে না শ্যামল যাদব ওটা অ্যাড হবে
তিনজন।
এই ধরো অ্যালাউ হচ্ছে না 19, অ্যালাউ হচ্ছে 35, অ্যালাউ হচ্ছে 36, ঠিক আছে, আর রিজেক্ট হচ্ছে 20, ঠিক আছে।
Deep, extremely.
ওই নামগুলো ওইভাবে করবো।
Obliged, my lord, extremely. Extremely. My lord, satisfaction of the learned trial judge. আচ্ছা পরের বলুন
52A
52A my lord ও তো টাইম নেবে
My lord, 56, 57, my lord, London public prosecutor is on his legs in court trial.
So, what we will do, London public prosecutor, when he will be not on his legs, tell us. Have you prepared a compilation?
My lord,
Give a copy to Sanjana.
দিয়েছি ওকে দিয়েছি হ্যাঁ my lord, I have supplied a copy of them.
You have read them. Then
আমাকে কপি দে ভাই
Joydeep is there too.
Item 6.
ওখানে একটা brief আছে আমাদের
মাখান চাঁদ
বলেছো
কে বলেছে
তুমি তো মাইলর বলছে মাখন চাঁদ থেকে শুরু করেছো।
Where is Justice Bela?
Justice Trivedi is my lord, এই যে NCB versus Kashish.
Right, Kashish and Justice Partiwal.
The last two, my lord, Bharat Ambale and Rajwan Singh, Justice Partiwal.
So we just have to consider those two.
One of the co-accused.
And I think after Justice Partiwala's judgment, the question of suspension of sentence on 52A is not made up. We will consider next. You can do whatever.
Try to, my lord.
Because the other batch of judgments, the three judgments of Justice Bindal and Justice Tanvi Mehta
and Justice Gawai,
they have been considered in the subsequent. Bharat Ambale,
my lord, the principles have been culled out.
I think 198 of your compilation is most relevant.
The principles have been culled out in
paragraph 50 of Ambale.
Yes. 198 para 50, our fine summarized. My lord,
after Ambale, also another.
Yes, by Justice Partiwala again. And that is not reported, but I found it from the website.
Oh, it has not been reported.
No, from the website I've got this. This is after Ambale.
The same tune.
My lord, there also, my lord, Justice Partiwala has reiterated the same, that the issue is now, my lord, foundational facts have to be laid by the defense before the advantage under section 50
So
can.
this does not apply at the stage of suspension of sentence.
My lord, that my lord, I will try to. My lord, if my lord, I have laid down.
If you argue, Mr. Mitra, we are making it clear, we'll dismiss your appeals here and now. If we are satisfied, there is foundation of fact. We do not waste time hearing counsels twice.
My lord, found, my lord,
if you are
come back next week.
A simple thing. If breach per se is going to attract point of law, otherwise factual inquiry, hearing in appeal. All right, we'll come 1 week. 1 week hence. So. That is why we wanted your assistance. As after Justice Padiwala's view, we can't give you suspension. Definitely, you can argue the point at the time of hearing of the appeal. Yes, Joydeep.
60. Three are together, my lord.
My lord,
which three are together?
My lord, the
59.
Oh, the 60.
My lord, 60.
Same
I'm for
point.
the app.
You are for whom?
My lord, I'm for the appellant in item 60.
3 appeals, my lord, there.
Huh?
Here, 58, 59 and 60 are 3 of the appellants from the same conviction. I am appearing in 59, he is appearing in 58.
This is not.
This is also 52.
This is also 52.
52.
We'll keep it 1 week.
Yes, my lord.
But I will only highlight
Jo-
2 pages of the judgment of.
Joydeep, you have got the compilation. Please get it from Sanjana.
I will also place one judgment, my lord, that is NCB versus Kasi.
There is history, there is development beyond Kasif. In fact, Kasif is a tentative judgment. More definitive view is given by Justice Padiwala in HON'BLE, which perhaps is against Mr. Mitra. He is fairly placed it and he said that I will distinguish it or I will explain how the ratio applies. Please go through those. Mr. Mitra, please give him at least the citation so that he
yes.
can
I'm doing DD.
prepare himself.
কোথায় গেল?
You know anything?
My lord.
What is HON'BLE?
But it's section 52A.
Ask him anything. He knows anything.
One indulgence for your lordship, kindly consider page 51 and 52 of the trial court's judgment, my lord. I think, my lord, perhaps the 52A was complied.
No problem. If it is complied, very good. 52A complied. We'll dispose of on that ground. Any other point if they take, they take. Not this week, next week.
No.
It's all together.
5 3 না 5
तिलक लगाते आए हैं महादेव पर Miss Manla.
Please, minutes. Minutes, we prepared the compilation that your lordship, minutes request, asked for the last time.
It's on another day. We'll keep this. You have filed a compilation.
Please, minutes, my learned colleague has that, minutes, that judgment is on record of Nagendra Shah versus State of Bihar, minutes.
Right.
Please, minutes.
One I was referring to. 61.
Please, minutes. That it says, minutes, 106.
Judgment, right?
Please, minutes.
22.
21 minutes.
21.
Please,
All
minutes.
we'll keep it on another day. একটা date দাও তো এটা We'll just go through the judgments, Miss Manla, and then, Miss, have you given it to the state lawyer?
My lord,
You've given to the state lawyer, you go through them.
Millets, in just that Millets in Nagendra Shah Millets, this is Justice Oak's judgment Millets. Millets thereafter Millets, there is Nusrat Parveen Millets by Justice Dipankar Datta Millets. It conciles all judgments on 106 Millets. Millets, the last, there is a judgment of Pradeep Kumar versus State of Chhattisgarh Millets by Justice Gavai. In that Millets is, please Millets, that there are two views.
Follows the Nageshwar ratio.
Please Millets, and it says that when there are two views, the one favoring the accused has to be taken.
You must have to go for the view it. All right, we'll go into that.
My lord, it is already with the record. The compilation is already
with the record.
My lord, last occasion we had submitted.
No, not last occasion. There are some
New one.
Madam, last occasion when Miss Mandla submitted, she took time to supplement her bunch of judgments with additional judgments.
My lord.
Have you given that bunch?
My lord, I had with the notes, new notes.
Let us
my
see.
lord.
61. The difference is, Ms. Mandla, we'll have to check into 302, you have a point. But if it goes down to 304B, how the impact will be in light of 113B?
Please.
Because what happens is 106 is against your presumption of innocence. But when you are charged with 304B, it's eroded by a reverse burden.
Please.
And there, 106 really is not the bridge which the prosecution needs to cross.
Please, minutes. Please.
Always rest its case on 304B, read with 113B. However, if that is where we see the prosecution resting its case, it would definitely be an arguable point on life imprisonment. That is the quantum of sentence.
Please, minutes.
Okay, we'll do it in that. The two arguments we need from you is A, are you making good the charge of murder? Second, let's say you are failing to do it. Is it enough to convict on the lesser charge of 340? Right? Correct. This is not the, see, it doesn't have the judgments which Ms. Mandla is indicating.
I apologize, Millets. We'll make sure that it's on record.
Out of her. We have got it. She's now giving it.
She had it yesterday, Millets.
I looked into the file. This judgment. Right.
Millets, yes, Millets. Nagendra Shah Millets is the 2021 judgment by Justice So that your lordship was referring to, Millets.
Kaluram 13. Dattaraya is, I think, Justice Gawai's judgment, 39. No, this is Varal. No, where's first one is Justice Anzabai. This again is not there. Miss Mandla, please do the like.
Nagendra Shah Millets, I hope she's given the right compilation to your lordships because we'd given it to her yesterday.
Please interact with your junior.
Millets, I will, Millets. I apologize. We sent it across to her.
Please ask her to put in the right bunch of judgments.
Two compilation which is
there is some communication gap between you and your senior, right? Please sit with her and give the right compilation. Supply to your friend.
My senior.
Millets, we'll file it, Millets, before the hearing so your lordship can, Millets, peruse them as well, Millets. Millets, we've gone through the trial court record again, Millets, but we were not able to find, Millets, the 311 application, Millets, for the PW22, Millets.
Or the doctor.
Please, Millets, it's not there, Millets.
Call upon the state to answer how he was summoned. Please look into fourth file, how the summon was sent to the doctor.
Malad, so far as the order itself is concerned, that reflects that the doctor was there on that very day.
How was he there?
Malad, because the report was there, my lord, exhibited. But the summoning of the doctor, my lord, that raises a question, my lord.
Not raises the question. There's no question. If you see the records, it would come out.
My lord. My lord.
Don't compel us to act as your junior. Please go
No,
through
my
the fourth file. That's a fat one.
My lord.
Because it contains all the summons.
My lord.
Relate to the date of his examination. Prior to that, he will get the summons.
Summons.
How the summon is served? Without summoning, the doctor came. This is quite peculiar. I saw the 311 application, but then that's not of the doctor. That's of the second IO.
Second IO. It was
Now,
not of the doctor.
did the second IO bring the doctor with him?
Minister, second IO also did not come, even despite the summons, Millards.
Not come, right?
No, Millards. And the trial court then just leaves him altogether and
How did the doctor come?
Doctor come.
We need to find out that, right? Please look into these papers if necessary. Talk with the public prosecutor in that case.
Trial court.
Trial court. You will find it from the fourth file.
No,
third and fourth file will, third file will
once.
give you the applications also. The fourth file are all the bonds, etc. They were submitted. What papers are filed? So that may also give you an indication. We have not seen anything with regard to summon to the doctor, but we have may have missed it because we only scanned it while sitting here.
No, my lord, I'll go through it.
Take some time. We are giving both of you time. We are putting this matter. (24th of February). Hey, sorry.
My lord, today is
sorry. 24th of March.
24th of March.
My lord, may I file the compilation tomorrow in the morning, your lordship?
No difficulty. You please talk to our officers and
My lord.
put in.
I'll mention it.
What you
at the
do
time of
is you
mentioning.
make one complete compilation, not piecemeal.
My lord.
That will help us.
My lord.
Correct?
My apologies, your lordship.
24th. Then we keep it on 19th of March.
19th of March.
These minutes.
For B करना
Deeply blessed.
My lord. Item number 1, my lord, I am for the petitioner. February, my lord, has to be 6 March.
Next.
Great.
My lord, item number 3, I'm for the petitioner. My lord, I'm being led by Mr. Pachal. He's not here today attending the. Kindly, my lord, keep it on Friday.
You are appearing in the other case also?
No, my lord.
Nobody is appearing in the other
No,
case. Nobody appears for the petitioner. Dismiss for default. Petitioner. Full stop. Dismiss for non-prosecution. Next. Yes, what is the report?
There are no report found.
What? Where's the joint petition of compromise?
Is grand number 1 and it is
এটা দিন দিয়েছেন আচ্ছা দিয়ে দিন
Petitioners have amicably resolved. Petitioners submit that the allegations in the impugned FIR relate to breach of copyright of the de facto complainant in the designs relate to breach of copyright of the de facto relate to breach of privacy and copying of personal and professional photographs stored in the Facebook profile, uploaded in the Facebook page of the de facto complainant.
Of the de facto complainant as well as a fan page which was licensed by
De facto complainant and her and another page, another account maintained by her followers. De facto complainant, now, in view of the nature of allegations, are personal and private and do not involve any public interest. De facto complainant has submitted a joint prayer for quashing of the proceedings. The nature of allegations in the charge sheet fall in category, though the offenses are not compoundable. Nature of the allegations in the charge sheet portray a private dispute which fall in the category of cases in Gyan Singh versus so and so, wherein this court, in exercise of inherent jurisdiction, may interfere and quash. Accordingly, learned lawyer for the state submit report that the investigating agency is unaware of any amicable settlement. Be that as it may, the joint petition being CRAN so and so clearly shows the willingness of the opposite party number 2 de facto complainant to withdraw the allegations. Accordingly, we are of the opinion no worthwhile purpose would be served to continue the impugned proceeding. Accordingly, proceedings being so and so are pushed.
I'm grateful.
I'm grateful, my lord.
Please give the citation of them.
Citation is here, my lord. Citation.
Just, you can. Next. Out of distance, try direction of out of distance. নেই কেউ ছেড়ে দাও না
Me please. My lord, I have come up against my lord, the order is of my lord, against an order where I paid for a discharge under section 227, my lord. My lord, what has happened, my lord? Let me say the background. The petitioner was a clerk. He was writing the register in front of other, my lord, the teachers and other staffs. He was, my lord, back distribution was going within the school premises and in the school hours. But suddenly, my lord, this case, my lord, came up. And my lord, the order of the London magistrate, I prayed for an order for discharge. If your lordship, my lord, comes to the order sheet, my lord. We have, my lord, filed a written objection also, my lord. But though it was taken, my lord, but if your lordship, my lord, comes to the portion, my lord, like 10 lines from bottom, my lord, of that order. And my lord, now he is undergoing, my lord, dialysis 3 times a week. He is in bed now, my lord. And his life is also limited, as I have seen from the my lord, the court records, that 1.5 years his lifespan is.
Petitioner has assailed order dated 21/8/2024, whereby his prayer for discharge from the case had been turned down. Prosecution case alleged against the petitioner is to the effect that on 22/1/2023, to the effect that where is the charge sheet?
But charge sheet is not with me, but that, my lord, the
show us the charge sheet.
Lord. But there is a charge sheet.
On 4/11/2022, the petitioner, who was a clerk in a girls' school, had misbehaved with 3 minor school-going children, 3 students, minor students of class 5 of the said school. Learned counsel contends that petitioner is an ailing person who is on dialysis. The incident is said to have occurred while bags were being distributed to students. A large number of persons were present, and the allegation of sexual assault is patently absurd. Statements of witnesses show the nature of sexual assault has been escalated, has been improved during investigation. Accordingly, learned trial judge failed to consider these aspects and prayed for this and dismissed the discharge petition. We have considered the materials on record. We have also considered the charge sheet, which is placed before us during hearing. It appears from the materials on record, it appears petitioner was a clerk of the school. On the fateful day, it is alleged that he sexually assaulted 3 minor students of class 5. Their guardians raised commotion, and the matter was informed to the school, to police by school authorities. During investigation, the minors have made statements before magistrate which implicate the petitioner. Learned counsel strenuously argues that the statements are at variance with other statements before police. And the victims were not medically treated. I do not find much force in these submissions. Uncontroverted statements of the minor victims implicate the petitioner. It would be unwise to hold a mini trial and test the correctness or otherwise of these statements on the anvil of other evidence on record. Full stop. Such exercise is best left to the trial court upon all evidence being adduced by the prosecution. Nature of sexual assault may be proved through the oral deposition, oral statements of the victims and other evidence on record. Failure to examine the victim, medically examine the victims, may not be relevant. Full stop. In light of the aforesaid discussion, we are of the opinion no case for interference is made out. Petitioner is at liberty to canvass his defenses during trial in accordance with law. Next. Petitioner prays for expeditious disposal of the case. He is a complainant. He is the complainant, and the case was instituted in 2018. The case is pending for last 6 years, for more than 6 years. Under such circumstances, we direct the trial judge to conduct the trial with utmost expedition and conclude the same at an early date without granting unnecessary adjournment to the parties. Next.
Your Lordship, I am for the petitioner. This is an application filed under Section 12 and 13 of the Protection of Women from Domestic Violence Act 2005. Before the Court of London Judicial Magistrate 7 at Alipur Court. Your Lordship, this case is filed in 2013. It's been more than 10 years that this case is pending. And the
Interim relief granted. What is the stage of the proceeding?
Evidence, your lordship, the opposite party needs to file the affidavit of asset and liability, but haven't filed.
You paid for interim relief.
No, your lordship, this is an application for expeditious disposal. I want a speedy trial.
Speedy trial of what?
Speedy trial of this.
What is this?
This is an application under section 12 and 23 of the Protection of Women Act.
Correct. Did you pray for interim reliefs in this proceeding?
Yes, your lordship.
You prayed for interim relief.
I just want a speedy trial.
How many briefs do you have?
No, this is
How many briefs do you have?
the first application.
Huh?
This is the first application.
First application. And in the first application, you do not know your case. What is the provision for interim monetary relief in a proceeding under the Domestic Violence Act? Do you have the Protection of Women from Domestic Violence Act with you?
No.
You don't have it in your mobile phone? Then you have it?
Yes, your
You do? See section 29 of the Act. Interim relief try pending. It is the architect. এই তো come to the papers. Come to the order sheet. See order dated 10/3/2016. You've seen?
Yes, your lord.
What have you seen? 10/2/2016?
Uh,
Prayer for interim relief. Now 10/3/2016, come to internal page 7. It is allowed 1,500. 1,500. Is that amount paid?
that I have take instruction from my client, your lordship.
You file the application without knowing anything. All right. Since you are indifferent, we will be equally indifferent. Petitioner is the aggrieved wife. She has prayed for expeditious disposal of the proceeding under Section 12 of the Protection of Women for Domestic Violence Act. She submits that the proceeding is pending since 2013. We have perused the materials on record, including the order sheet. On 10/3/2016, interim monetary relief was granted to the petitioner. However, proceedings are pending till date. Under such circumstances, we direct the jurisdictional court to dispose of the proceeding as expeditiously as possible without granting unnecessary adjournment. This is not the way in which a client expects assistance from you. You have one brief, first appearance, but you have not read your papers. What prevents you from reading papers? You have not read your papers. When we ask that, is there an interim relief interim relief granted. No, you don't know. Now, madam, there is so much of lawyers. Why will a litigant have faith in you? Until and unless you give everything and know all facts. We know you are a young lawyer. You may not be experienced to interpret law, but facts should be at the back of your hand because you do not have as many cases as maybe a more senior lawyer. You have to shine out somewhere, be exceptional. This is exceptional in the reverse. You don't know even the basic state of the case, the stage at which you are approaching, what is harming. The first thing,
Lordship, can you give me another date?
no, these are waiting for long. And what they are waiting for? Expeditious disposal, according to me. Oh, madam. Next.
Well, I've got the petition.
Yes.
Well, a dispute relates to non-supply of the articles. Well, the amount has been paid for medical equipments, but that has not been supplied. Your lordship will
You
get
have
the
considered the materials on
the
record.
entire amount has been paid.
The allegations, it is contained, learned counsel for the petitioner contends that the dispute arises out of a commercial commercial transaction and at its height discloses breach of contractual obligations. Ingredients of the offenses are not disclosed. We have considered the materials on record in light of the aforesaid submissions. Petitioner has made out an arguable case in his favor. Stay 6 weeks, 4 weeks service. Next. Yes.
My lord, I'm for the petitioner. I'm led by Mr. Udayshankar Chattopadhyay, my lord. The petitioner is an unfortunate mother of the deceased, my lord. On 27th August 2020, the petitioner was informed that her son was missing, and on 28th, she lodged a missing diary, my lord. And on 29th August, the body was recovered from a water body. My lord, the principal accused is his wife, my lord, who is a constable. My lord, the investigating officer already, my lord, submitted a FRMF report, my lord, and the petitioner was filed an Narazi petition, and the Narazi petition was also allowed, my lord. But further, my lord, the investigating officer conducted the proceeding in a lackadaisical manner, my lord.
Then what happened?
My lord, till today, my lord, nothing happened, my lord, regarding this investigation. And my lord, I'm praying for the transfer of investigation to CID, my lord.
Not in criminal division. You have to file a writ petition. To file a writ petition.
My lord, already final report was submitted by the.
No, final report has been submitted. Further investigation has been directed.
Yes, my lord. But my lord, after the
Petitioner
Narazi petition allowed,
her son was murdered and no proper investigation was done. She prays for investigation by a specialized agency. Copy of the petition be served upon opposite party state. Matter will appear 2 weeks hence as contested.
grateful, my lord.
Next.
Lord, I am appearing on behalf of the petitioner. Quashing of the entire proceeding. Well, the petitioner is a businessman and he runs a foreign liquor on shop having valid licenses. On the intervening night of 17th of May 2024 and 18th of May 2024, when the petitioner was closing his shop and was taking preparation to go to his residence, the opposite party number 2, being a civic volunteer, along with another person, came at the spot. He asked what he was doing there at late night, and thereafter, my lord, mercilessly beaten. My lord, on the other hand, when I called the officer in charge of the concerned police station, he arrested me with an allegation. My lord, case started under section 341, 332, 333, 353, 183, 427, 506, and 34 of the Indian Penal Code. My lord, when I have filed this criminal revisional application, subsequently, my lord, charge sheet has been filed, and my lord, kindly allow me to file the section 207 copies with this supplementary affidavit, my lord, wherein I have stated, my lord, all the persons who were the civic volunteers who were not on duty at that place of at that spot, my lord, they gave witness. Not only that, my lord, they even were unable to state regarding the place of occurrence. If your lordship kindly sees, my lord, page 25 onwards, your lordship will find that there is contradiction regarding the place of occurrence even. My lord, if your lordship kindly comes to page 25, there said
Medical report is there.
My lord, medical report. I was injured, my lord. I have annexed the photographs as well as, my lord, the page number 33. Page number 30.
Medical report
Yes.
of the civic volunteer was there.
Yes, yes. Page 33 onwards.
Then
Bivas Chakraborty. Page 33.
Then
no external cut injury.
Mr. Chatterjee, it will be a case and a counter case to be tried together.
My lord, no counter case. I was not allowed to lodge. No, I
couldn't lodge a 200.
I was arrested, my lord.
All right. No, your wife couldn't lodge a 200 complaint. You were arrested.
My lord, kindly sees the injury report. My lord, no injury. They have annexed injury report. But my lord, kindly sees whether there was any injury or not. No external cut injury. Injury on the left hand dorsum as well as the pain and swelling.
That's no injury.
Clinic, matlab, thereafter, clinically simple type of injury.
Naturally, so simple injury is a tribal issue.
My lord, my humble prayer is, my lord,
This
he was a
is not-
civic volunteer. These sections cannot be attracted, my lord.
That you argue at the time of framing of charge.
Well,
Petitioner,
that liberty may be given, my lord, I shall argue, my lord.
petitioner submits that he is the owner of a foreign liquor shop. The opposite party number 2 is a civic volunteer and cannot be treated as a public servant. They intervened and harassed the petitioner. When he objected, a criminal case was slapped on him. He prays for quashing. We have considered the materials on record, including the annexures in the supplementary charge sheet. In the FIR, it is alleged on 18/5/2024 at 2:15 a.m., petitioner and his associates had assaulted the civic volunteer and snatched away his torch and lathi. Full stop. Though it is contended that the allegations are malified and leveled to cover up the excesses at the end of the civic volunteer, I am of the considered view. I note that the materials collected during investigation include medical documents showing assault on these civic volunteers. It cannot be said that the allegations are not supported by material evidence. The other issue in respect of malifieds is a question of fact which required to be agitated at the appropriate stage of the proceeding. Hence, we do not wish to interfere with the proceeding at this stage. It is open to the petitioner to canvass his defenses at the appropriate stage of the proceeding in accordance with law.
Grateful, man.
Next. Supplementary act.
I'm for the petitioner. I will kindly come to page number 105 once. My wife remarries someone else, gives birth to someone else. Thereafter, she continues her claim of maintenance. I will kindly see page 105.
Petitioner submits
Kindly see once.
Petitioner submits that the opposite party wife has remarried. Accordingly, he prays for setting aside the execution proceedings.
Kindly see once 105.
Execution proceedings are pending before
May I
the
only place before the trial court?
It is open to the petitioner to agitate these grievances.
That was done. Kindly see order number page 118. 118.
118.
118 before the execution court, everything was placed.
Yes,
118.
Execution code, you have to ask for modification of the maintenance allowance.
127. The execution code, it was filed before the. I know. May I only say,
if you are to file before another proceeding,
same judgment. May I only say, I will file before the trial court. 127. Keep in abeyance. Kindly the
Zero.
She remarries, she gives birth to a child.
Does not matter. Till the date of remarriage, liquidate.
No, she remarries before. That's why I wanted to show your lordship, my lord. At the moment she leaves in 2019, she remarries in 2021. She suppressed everything, files a 125.
These are all questions of fact to be probabilized.
No, I just want to show one document, my lord.
You can show
the hospital records. The hospital record shows, my lord.
Before the magistrate.
Till that time, my lord, some relief.
No way. Petitioner,
at least I can pray for a time-bound disposal of my 127 application, my lord.
It is open to the petitioner to agitate these issues before the magistrate and pray for modification of the maintenance allowance maintenance allowance granted to opposite party number 2, opposite party wife.
My lord, may I only pray for a time-bound, my lord, disposal of my 127 application, my lord.
Next.
My lord, I am on behalf of the petitioner. In a 138 case, lordship, the trial court held guilty, and thereafter we prefer an appeal. Appellate court also Lordship found guilty and
Deposit certain sum.
I have already deposited.
How much?
2,20,000. 2,60,000. Lordship.
Only.
That is the order, Lordship. It is to this.
20%.
Order by whom?
This court, coordinate bench of this court, and thereafter I have deposited in
What
trial court.
coordinate bench of
In compliance to the order, I have deposited in trial court, Lordship. And the trial court order is also there.
This is something else. This is 20% under 143 capital A.
Lordship, as per Honorable Court's order, I have deposited before Lordship, the trial was, before Lordship,
That is under 143 capital A.
Lordship.
Now it is at the stage of conviction.
Lordship.
So you
Now, after conviction, I have deposited, Lordship. In trial court, I have convicted. Thereafter, I have deposited. After conviction, I have deposited.
we have petitioner contends that what was the check amount?
Lordship, 12 lakhs, 10,000.
12 lakhs, 10,000. And what was the 20 lakhs?
Lordship. And 13 lakhs compensation amount.
Huh?
13 lakh compensation amount.
In fine, 20 lakhs. And you were only directed to pay
20 lakhs.
20 lakhs of the compensation.
Which compensation, Lordship? 10 lakh.
How much have you deposited?
2,60,000.
2,60,000, that is the order.
2,60,000, how?
That is the order of the Honorable Court.
Now, Honorable Court is over now. Now, Honorable Court is me. Now, let us see what. Your amount is fine of 20 lakhs and 13 lakhs as compensation. So, altogether, it is 33 lakhs.
No. 20 lakhs. 13 and 12, Lordship.
Oh, 13 and 12. All right. What is 20%? What is 20% of 20 lakhs?
4 lakhs.
4 lakhs. So you deposit 4 lakhs.
Lordship, I have already deposited remaining.
Remaining you deposit.
Lordship, kindly direct, I will deposit.
All right. Petitioner submits that the appellate court failed to consider the relevant issues of fact and law raised by the petitioner. He has already deposited a sum of rupees 2,40,000.
No, 60,000.
2,60,000.
2,60,000 at the time of admission of the appeal. Full stop. Having considered, he prays for admission of the petition. At the having considered, I have perused the impugned order. Having impugned order, I direct the petitioner to deposit a sum of rupees 4 lakhs, a sum of rupees
1,40,000.
4 lakhs, that is 20% of the fine amount awarded. In all, a sum of rupees 1,40,000.
1,40,000.
40,000. That is, in addition to the amount already deposited before the appellate court, that is 2,60,000. Deposited by the that is rupees 4 lakh in all within 7 days from date. In the
Lordship, can you make it 15 days? 15 days.
Then 6 lakhs.
No, Lord.
Within 7 days from date. In the event the said amount is deposited, there shall be stay of the operation of the impugned judgment and order dated so and so এগুলো বলে 6 weeks, copy 4 weeks, so and so opposite party shall be permitted to withdraw the amount deposited upon executing a bond to the satisfaction of the trial court, that the same shall be refunded, that the said withdrawal shall abide by the result of further orders of this.
I'm good.
Let them get at least 4 lakhs out of you.
না তোকে আমি পরে দিয়ে দেবো টাকাটা দিই এটা একটু দিয়ে দেবেন তো
In the event he fails to deposit within the time stipulated, interim order shall stand automatically with it. Next.
My lord, for the petitioner, my lord, I am appearing virtually. Lordship, 8,000 rupees, Lordship, was directed to pay the opposite party in a proceedings under section 2023 while disposing an interim application of DV Act. 29 appeal was preferred by the opposite party husband. It was reduced from 8,000 to 5,000.
Petitioner submits that the appellate court illegally reduced the maintenance allowance, interim maintenance relief granted to the petitioner wife. Full stop.
My lord.
I have considered the impugned judgment. The order is an interlocutory one. At the interim where is the copy of the judgment? Huh? Where is the copy of the judgment?
Lordship, I have annexed the order, Lordship. The judgment is not.
Petition is
probably is mistakenly missed, Lordship. The order is
and dismissed. Next.
Lordship, kindly grants the liberty, Lordship, to file.
So pathetic.
Lordship, I'm extremely.
Go write a letter of sorry to the client. Not
Lordship,
to
inadvertently it has been missed, Lordship.
Oh no.
Lordship, I'm come up with a supplementary affidavit, Lordship.
You went to a medical doctor and he did this to you. Will the sorry suffice? Next.
Lordship, with the liberty to file afresh, Lordship. Kindly accord the liberty, Lordship.
Yes.
স্যার এই কেসে ট্রায়াল কোর্ট পুলিশের ইনভেস্টিগেশন এবং রি-ইনভেস্টিগেশন রিপোর্টের ভিত্তিতে জাজমেন্ট পাস করেছেন, যেখানে অনেক অ্যাভেলেবল উইটনেস এবং অ্যাভেলেবল ডকুমেন্টারি এভিডেন্স থাকা
Copy of
সত্ত্বেও
the application be served upon opposite parties. Opposite party number 1 through public prosecutor, 2 to so and so to register speed post, file affidavit of service, contested application 4 weeks since. Next. Sixteen.
16 will to appear on behalf of the petition. Will it is upon notice? Well, the service is complete. Dada.
Yes.
Dada. Dada.
Not today. Next.
17.
Yes.
My lord, for the petitioner, item numbers 17 to 20 and thereafter 23 to 27 are all similar 9 applications.
17 to 20.
20 and thereafter 23 to 27.
23 to 27.
All similar applications. These are expeditious applications for complaint cases. Those are pending before 5th JM at
Stage of proceedings.
Sorry, my lord.
Stage of the proceedings in this
Yes,
case.
it is in the evidence before stage.
Evidence before
Evidence before charge stage, my lord.
Evidence before charge.
Yes, because my lord, these complaint cases are under section 138 of NI Act, and along with this 420 section and 34 of IPC is also included.
Oh, 420 has also
Yes,
been added.
yes. And
if 420 was not added, then what would have been the procedure?
then 143A would have been applicable. Interim
143A is interim relief, but
Yes.
what would be the procedure for trial?
Sorry, my lord.
Charge would be framed.
Yes, my lord.
Yes. What's the difference between a warrant triable case and a summons case?
My lord, in case of sections 420 and 34, in that case, 143A interim compensation relief cannot be filed up before charge is
Why?
framed.
If 138 is there, why cannot 143A be filed?
Because, my lord, in this case, 420 and 34 penal sections.
How does that impact prosecution under 138? What is the difference?
The difference is, my lord, in case of 420.
Addition of 420.
Yes, my lord.
How does it change the character of the proceeding?
Because the sections are Indian Penal Code sections and investigation officers are not included in this complaint cases.
Complaint case, there is an investigation officer.
No, this is not included. This is not registered by an FIR, right? So in that
It
case,
is registered by what?
by complaint case, my lord.
By complaint.
Yes. And that is why learned lower court has fixed for this evidence before
The
charge.
question is, the complaint discloses offences under Indian Penal Code, offence under the special law, NI Act.
Yes. Yes,
Now, which procedure will be followed? NI Act procedure or the procedure under Code of Criminal Procedure?
My lord, in NI Act, it is specifically mentioned in the provision 143A clause 1B that in other cases, interim compensation petition can only be filed upon charge.
Right.
Not before that. In other cases, it can only be filed upon charge.
So 138 is already there.
143A.
See 143A.
Tick mark করা আছে না? Hello, I have ticked it. Yeah.
Right. Now, why in summons case, why in 138 it can be filed before that?
Sorry, Mala, I didn't get your question.
If 420 was not added,
Yes.
then how the proceeding would have continued?
Then petitioner would have been allowed to file interim compensation petition.
Forget about the interim compensation petition.
Yes.
Is a charge required to be framed?
Yes, my lord.
In a 138 case, see clause A of 143A.
Can you give me the book?
Petitioner submits that the proceeding under the
Summary trial or summons case where he pleads not guilty to the accusation made in the complaint.
then
Yes, my lord.
when will that apply? Petitioner prays for expeditious prosecution in the instant complaint case being so and so. The
My
proceeding.
lord, may I mention something, my lord?
Yes.
My lord, in this section 148 clause 3 of NI Act, trials shall be concluded expeditiously within 6 months. That has been the mandatory provision of NI Act.
Again, come to clause A. What is clause A saying? Trial by in a
Summons case where he pleads not guilty to the accusation.
A again. What does it say?
In a summary trial or a summons case where he pleads not.
Correct. Now come to 147, which you were showing. 147, where the time frame is given.
Okay. Yes.
The procedure.
Every trial under this section shall be conducted as expeditiously as possible, and an endeavor shall be made to conclude the trial within 6 months from the date of filing of the complaint.
So this is a special law.
Yes, my lord.
So the special law for 138.
Yes, my lord.
Governs offences.
Only under 138A, right?
In this special law.
Yes, my lord.
Where it prescribes a summary trial.
Yes, my lord. I understand.
The summary trial.
My lord, I understand that.
What is a summary trial?
That, my lord,
Is there any provision for summary trial in the Code of Criminal Procedure?
Yes, my lord.
Is there?
Yes, my lord.
Are you sure?
My lord.
How many types of trials are there in the Code of Criminal Procedure?
Okay, but that is fine.
Summons trial as a summons case. trial as a warrant case, sessions trial.
Yes, my lord.
Summons case may be tried in a summary manner. 138 prescribes that summary trial.
Yes,
and
my
that
lord.
is what we are trying to indicate.
Yes, my lord.
When you add 420, it cannot be tried as a summons case because the punishment is up to 7 years.
Yes, my lord.
When it is up to 7 years, it has to be tried as a warrant case, and then the charge has to be framed.
Yes, my lord.
But in a summons case, what is framed instead of a charge? That you don't know, please go and see. It is plea. A
Yes, my
plea
lord.
is
Yes, yes. I understand. Yes, my lord. Absolutely, yes. Not charge. It has to be plea, yes.
right.
Yes, my
So,
lord.
so you
I
have
could
to,
recollect now,
you
yes.
have to know this difference.
Yes, my lord. Absolutely, yes. I could recollect now, my lord. My only prayer is the lower court below is fixing up the dates
We'll pass the order.
after
don't worry.
5 to 7 months between
We'll
each
pass
date.
the order. Don't worry.
No trouble.
Case number so and so. We have considered the materials on record. Complaint was instituted in 2023 and date has been fixed for recording pre-charge evidence. We are keeping in mind the aforesaid facts, pre-charge evidence. The prosecution of the case not only relates to offense under section 420 IPC, but also under 138 NI Act, full stop. Section 147 of NI Act, inter alia provides that trial of such offences are to be conducted in a time-bound manner. Full stop. Keeping the mandate of the special law in mind, we request the trial court to fix dates at short intervals and consider the issue of framing of charge at an early date without granting unnecessary adjournments to either of the parties. In the event the charge is framed, the proceeding shall be taken to its logical conclusion in accordance with law. All right?
Deeply
Same
obliged.
order governing all.
Much obliged.
সবকটাই শুধু কেস নাম্বার গুলো চেঞ্জ করবে। Yes, now 21.
It's my application, my lord. My lord, proceeding under section 498A filed by in the form of complaint, I got stay by this honorable court. The day when copy was served, a 94 application was filed before the learned SDM court and order was passed to seize all goods and IOS seized goods. Very good. My lord, kindly see in this manner, my lord, the proceedings were stayed. Just, my lord, kindly come to page number 93.
No. Tridon articles, independent proceeding, we are not going to interfere.
But proceedings, the proceeding.
We are not going to interfere.
That proceeding was stayed.
Tridon articles, you go and make an application before magistrate. If the articles seized do not constitute Stridon.
But that proceeding was stayed.
That is 498A proceeding.
My lord.
Not 406.
But
we are not.
498, 406, both was there.
All right.
Both was there. My lord.
Application has been not filed in that case. Separate application was.
No, 498, 406 complaint case was there.
Correct. The
That was stayed by this honorable.
application is independent.
Independent in SDO case. My lord, parallelly, this
All
proceeding
right.
is pending.
Copy of the application be served up. Petitioner submits that the proceedings being so and so, alleging 498A, 406 IPC has been stayed in CRA so and so. Copy of the application be served upon opposite party through registered speed post. The CRR 4046 of 2024 shall be heard along with so and so.
Well, deeply obliged.
Next. 22.
In 22, my lord, I am appearing for the petitioner, my lord. Here, my lord, one FIR was lodged in 13th October 2022 against the petitioner, my lord. Here, the case is, my lord, at the time of immigration from India to Bangladesh, I got arrested at the immigration counter, my lord. Where, my lord, the ICP stated and lodged an FIR written complaint upon written complaint, my lord, against me, my lord, stating that I am not a resident of India. But, my lord, I have kindly see, my lord, page 8. In continuous page, my lord, I have annexed my documents relating to my residence here in India, my lord. I am the permanent resident of India since birth, my lord. And my father.
Petitioner submits that he is an Indian national. He was residing in India and has an Indian passport.
Yes.
Accordingly, prays for quashing of the impugned proceeding. We have considered the allegations in the charge sheet. In the charge sheet, it is alleged on 13/10/2022, petitioner had approached the immigration counter for immigration clearance for departure from India to Bangladesh. He had produced an Indian passport being number ওই page 132 তে পাবে, হ্যাঁ, Z761. However, profiling of the petitioner's biodata, it was revealed that he is a Bangladeshi citizen by birth. It is alleged in the charge sheet, it is alleged he had procured the Indian passport on the basis of fake documents. These issues are triable. These issues are now whether the petitioner had procured the Indian passport on the strength of fake and forged documents is a question of fact which can be best adjudicated in course of trial. In uncontroverted allegations in the impugned charge sheet disclose ingredients of the offense of cheating and forgery. Hence, we are not inclined to interfere with the impugned proceeding. It is open to the petitioner to agitate his grievances before the trial court in accordance with law. Next.
I'm obliged, my lord. Okay. 22 liquidations.
Yes, what is there?
So, number 2 made a complaint made an FIR regarding stolen of the Scooty lot. Stolen of the Scooty two-wheeler lot. And that has been not recovered till late lordship and charge sheet has not been submitted.
It's not a case of stolen of Scooty. It's a question of assault. 323, 325, 307.
My lord, I'm for the petition.
Yes.
20. My lord, we are the in-laws. My lord, yes, sir, counter. My lord, 20. My lord,
Yes.
my lord, the case and counter case, my lord, earlier, my lord, we filed.
Scooty.
My lord, we.
To return the Scooty.
My lord, I'm for the petition.
Return the Scooty.
My lord, the Scooty. My lord, I will take instructions, man.
Either you return or we don't quash.
My lord.
Monday. Get your Scooty. Both cases will be squashed.
My lord, 3 cases they have filed against me.
Both
Two
cases, all cases will be squashed. Get back the Scooty. Put an end to everything. We are keeping it on Monday. Talk to your clients. It's useless to continue this sort of case.
My lord, I bow down to you.
But what their main grievance is, you're not returning the Scooty. And when they come, you go on assaulting.
My lord,
We don't want your lecture.
No, my
First, return the Scooty.
My lord, I will.
If they return the Scooty, please persuade your clients that this sort of case you will take around another 7 years. So let there be a hiatus. Monday.
I will.
Next.
I'm for the petitioner, my lord. This is the application for quashing, my lord. The section is 498F 406. I am the husband. Actually, my lord, after the 1 month of the marriage, the complaint was made. There actually no incident is occurred, and all article has been returned. Out of 4 accused, two accused already discharged from the charge sheet list.
Very good. Husband will not be discharged. We have considered the materials on record on 8th December 2022. Petitioner married opposite party number 2. After 1 month after marriage, she was subjected to torture and physical and mental torture. When she became pregnant, petitioner opposite party number 2 was subjected. When she became opposite party, petitioner had assaulted her, had kicked her in the stomach, she took refuge at her parental home. When she brought the matter before mediation, petitioner and other in-laws assaulted them. Uncontroverted allegations, learned counsel for petitioner submit. Some of the in-laws have been discharged in the case. Uncontroverted allegations primarily implicate the allegations in the imputed charge sheet are primarily directed against the petitioner husband. It is alleged he subjected her to torture and even kicked her in the stomach when she was pregnant. In light of the aforesaid materials on record, we are of the opinion ingredients of the alleged offences under 498A and 406 are disclosed, and the petition and the proceeding does not call for interference at this stage. Petitioner is at liberty to agitate his grievances at the appropriate stage of the proceeding in accordance with law. Next.
My lord, I am appearing on behalf of the petitioner. This is an application for.
Sorry, in this matter, who are the petitioners?
Petitioner husband.
Item
number 29.
29. Okay, sorry. I thought the in-laws have also come. In-laws have a case, but not a husband.
Yes, my lord, item number 30, my lord. I am appearing on behalf of the petitioners. This is an application for quashing of the proceedings, my lord. Petitioner number 1 is the husband. Case under section 498A, 323, 406, 506, and 34. Petitioner number 2 and 3, my lord, are the parents-in-law of the opposite party number 2. My lord, we find from the letter of complaint, the primary allegations are against the petitioner number 1. There are some general allegations against petitioner number 2 and petitioner number 3.
Petitioners, we have considered the materials on record. Allegations in the impugned FIR and charge sheet are primarily leveled against the petitioner number 1 husband. Though it is alleged that petitioner number 2 and 3, that is parents-in-law, aided and abetted the husband, the allegations leveled against them are general and omnibus. Petitioner number 2 and 3 have made out an arguable case for quashing of the impugned proceeding. Now, it is argued that they have been falsely roped in the matrimonial dispute. Petitioner has made so and so. There shall be 4 weeks. Copy of the petition be served upon opposite respondent 1 to public prosecutor, 2 through register speed post, file affidavit of service. There shall be stay of proceeding for 6 weeks. So far as petitioner number 2 and 3 are concerned, proceeding against petitioner number 1 shall continue.
Apply.
Next.
May it please your lordship, my lord. No, I'm for the petitioner. No, the petitioners have come before your lordship challenging the entire proceeding, my lord. My lord, this is a case under section 498A, 496 and my lord 34. Now, my lord, the petitioner number 1 is the husband and petitioner number 2 is the mother-in-law, 60 years old. Your lordship, my lord, kindly takes page 25, my lord, the written complaint, from where your lordship will find, my lord, the allegations are in respect of that she was being abused, with filthy language, omnibus, my lord, there is
Petitioners are the husband and mother-in-law of the victim of the opposite party number 2 wife. It is contended that the allegations of torture and cruelty were not. It is contended that the crux of the dispute was that the opposite party number 2 wanted to live separate with her husband. Accordingly, they pray for ingredients of the offense punishable under section 498A are not IPC are not disclosed. I have considered the materials on record in light of the aforesaid submission. Statements of witnesses disclose petitioner number 2, the mother-in-law, used to abuse opposite party number 2 in filthy language. Full stop. However, the imputations, the exact imputations are not stated in those statements in order to ascertain whether such conduct would fall within the penal ambit of section 498 capital A IPC. In respect of petitioner number 1 husband, it is contended though he also misbehaved, though he sometimes subjected opposite party number 2 to physical torture, the latter wanted to reside with him in separate mess. This triggered the institution of the criminal proceeding. Accordingly, in this backdrop, we are of the opinion petitioners have made out an arguable case for quashing, stay of proceedings for 6 weeks, service.
I'm grateful. I'm deeply.
Next.
Well, I am for the petition. Well, this is about the landlord tenancy dispute, my lord. The
Landlord
matter-
tenancy dispute is
Yes.
cannot be assault.
Yes, my assault, my lord,
Then-
the maternal uncle was the, my lord, the tenant, but the petitioner, my lord, never present at the place of occurrence. My lord, kindly page 10 is the complaint, my lord. But only সমীর দাসের ভাগ্নে বিশ্বরূপ কর্মকার পাশে দাঁড়িয়ে আছে মানে there is no মানে that day মানে he is the residing in his place মানে is not present in the place of incident.
কর্মকার Injury report is there, they are saying. Injury report is there.
But is there any problem between the maternal uncle and the landlord? The petitioner hearing is not not present at the place of occurrence. No allegation against the petitioners.
Where is the FIR?
FIR page 10, my lord. FIR starting from page 9.
Petitioner submit that he is a relation of the petitioner submits that his maternal uncle Shomir Das is the landlord and de facto
It's a tenant.
is a tenant and the de facto complainant is his landlord. A dispute over the tenancy is persisting between them. Out of grudge, petitioner has been falsely implicated. He prays for quashing of the proceeding. We have considered the allegations in the impugned FIR. The allegations are primarily leveled against Shomit Das. Full stop. Presence of the petitioner is merely noted.
Witness টা কোথায় করেছে? Witness? Witness টা না, আমরা ছিলাম না কোথাও। সেটা আমরা pleadings এ বলেছি।
Is against though full stop against Shomit Das full stop. It is alleged petitioner had torn the wearing apparels of the de facto complainant. No torn wearing apparels have been seized in the course of investigation to corroborate this fact. Petitioner has made out an arguable case for quashing. Stay of proceedings so far as petitioner is concerned, 6 weeks, 4 weeks.
Yes.
Next.
Lordship, I am for the petition. Lordship, quashing of the proceedings filed under section Lordship 354, 354D, 506, 509 and 34 of the IPC Lordship. Lordship, allegation against accused number 1 Lordship. De facto complainant has hired the accused number 1 as the videographer and cinematographer of her YouTube channel. Subsequent thereto, accused number 1 has given some indecent proposals, and on 29th of 2021, 29/11/2021, she has been abused in filthy language. That is all the allegations, Lordship. With her sister-in-law, that is the present petitioner, Lordship. Lordship kindly comes to its FIR, Lordship. It's a part of the certified copy.
Charge sheet filed.
Lordship.
Huh?
Lordship, charge sheet has.
Charge sheet is filed against you in under what section?
Lordship, same sections. 350 354. It's last two pages, Lordship. Certified copy.
FIR, let us see that.
Lordship, just before the charge sheet, Lordship.
Hmm. We have considered the petitioner submits that the allegations of outraging modesty petitioner submit that the allegation leveled against her is that she had abused the opposite party number 2. No other allegation is leveled against her. Having considered the extent of complicity of the petitioner in the impugned charge sheet, and as neither the charge sheet, impugned charge sheet, we have considered the extent of complicity of the petitioners in the impugned charge sheet. No exact imputations made by the petitioner is not stated either in the first information report nor in the charge sheet. Ingredients of the offenses under 506, 509 IPC, ingredients of the alleged offenses are not made out against her. Stay of proceedings for 6 weeks, so far as petitioner is concerned. Proceedings shall continue against co-accused.
Lordship, kindly give me the liberty to amend the cause title, Lordship.
Liberty to amend. The co-accused is, what is his name?
Lordship, it has been written as the wife of the accused number 1.
Samrat Dash.
Samrat Dash.
Samrat Dash. Will continue.
Keep your pleasure.
Next. Shall continue. Next.
If I may please, your lordship. My lord, this is an application, criminal revisional application filed against a complaint proceeding for under section 406, 420, and 120B of IPC. Your lordship, the criminal proceeding is the complaint is basically civil in nature. There is an arbitration clause.
Where is the complaint?
Your lordship. Complaint, your lordship, will find at page number 20.
Petitioners submit that the allegations in the impugned petition of complaint disclose a case of non-payment of goods delivered, ingredients of offences of cheating or criminal breach of trust are not disclosed. We have considered the above allegations in the petition of complaint in the light of the aforesaid submission. Petitioner has made out an arguable case. Aforesaid submission, mere breach of contractual obligation would not constitute offences of cheating or criminal breach of trust. Petitioner has made out an arguable case for quashing, stay of proceeding for 6 weeks or until further notice.
Deeply pledged, my lord.
Other matters next day.